Welcome to Sriram's IAS. Today's lecture is on fundamental rights. Fundamental rights are enshrined in part 3 from Article 12 to 35. Okay, so fundamental rights, the provision of the fundamental rights, the Constitution provides for fundamental rights. They are enshrined in part 3, contained in part 3 from Article 12 to 35. So, why are these or why are these called fundamental rights? They are called fundamental rights because they are protected and guaranteed by the Constitution. Okay, they are protected and guaranteed by the Constitution. They are called fundamental. The name fundamental rights is given because they are protected and guaranteed by the Constitution. As you already know, the Constitution is the fundamental law of the land. Okay, so they are protected and guaranteed by the Constitution, and moreover, they are very essential. They are very essential for the overall development of the individual. They are very essential for the overall development of the individual. So, these are called or named fundamental rights. Now, what is the objective of the fundamental rights? The objective of the fundamental rights is to promote the ideal of political democracy. So, what do you mean by this? That is, political democracy imposes reasonable restrictions on the rights of the individual to prevent the establishment of authoritarian or despotic rule and to protect the liberties and freedom of the individuals. Okay, so political democracy imposes reasonable restrictions on the rights of the individuals to prevent the establishment of authoritarian or despotic rule. Okay, and to protect the liberties and freedoms of individuals. Okay, so political democracy imposes reasonable restrictions on the rights of the individuals and prevent the establishment of authoritarian or despotic rule. Despotic by a single person. Okay, that is, it is against or opposite to democracy, and to protect the liberties and freedom of the individuals. Okay, so this is to prevent and this is to promote. Okay, at the same time they are imposing reasonable restrictions on the right of the individuals. Now, the fundamental rights is inspired, or the inspiration. What is the inspiration, or from where it is derived from? The framers of the Constitution in this regard, that is, they have taken the fundamental rights, or they are inspired by Constitution of USA, that is Bill of Rights. The fundamental rights are taken from or are inspired by or derived from the Bill of Rights, the Constitution of USA. Now, the Bill of Rights in the Constitution of USA are absolute, whereas the fundamental rights in the Constitution of India are qualified. Now, what does absolute and qualified mean? So, the fundamental rights are derived from the Bill of Rights, that is from Constitution of USA, and these Bill of Rights are absolute, whereas fundamental rights are qualified, the fundamental rights enshrined in the Constitution. Now, what is absolute? What do you mean by absolute and qualified? Absolute, you are talking about Bill of Rights. Qualified, fundamental rights. Okay, so absolute Bill of Rights, the Constitution of USA, the state can impose reasonable restrictions on the rights of the individuals for collective action as evolved by the judiciary. Okay, the state can impose restrictions as evolved by the judiciary. That is, the Constitution, there is no provision, or the Constitution does not provide for the restriction of rights of the individual. It is evolved by the judiciary. Okay, whereas the qualified, the state can impose reasonable restrictions on the rights of the individual. Now, these reasonable restrictions are subject to the decision of the courts. Reasonable restrictions are subject to the decision of the courts, that is judicial review. So, any law that is inconsistent with the Constitution can be declared null and void. Okay, so in India the fundamental rights are qualified. In USA, Constitution of USA, your Bill of Rights, these Bill of Rights are absolute, that is, both the cases the state can impose, but here the Constitution does not provide for the reasonable restrictions, they are evolved by the judiciary, whereas in qualified, the Constitution itself provides for the reasonable restrictions. Okay, so here the state can impose reasonable restrictions on the rights of the citizens, and these reasonable restrictions are subject to the decisions of the court. If any restriction is against the Constitution, the court can declare it as null and void. So this is about absolute and qualified. So what are the categories of fundamental rights? Categories of fundamental rights. Originally there were 7 fundamental rights. Okay, 7 categories of fundamental rights, but right to property has been taken away or repealed, and right to property Article 31 has been repealed by the 44th Constitutional Amendment Act 1978, and it has been replaced by Article 300A Part 12. Okay, so This right to property, which was a fundamental right, it was made into a constitutional right. Constitutional right under Article 300A, Part 12. Now, what are the categories of fundamental rights? Right to equality, 14 to 18. Right to freedom, 19 to 22. Right against exploitation, 23 to 24. Right against exploitation, right to freedom of religion, 25 to 28. Cultural and educational rights, 29 to 30. And finally, right to constitutional remedies. Article 32. As you know, Article 31. As you know, Article 31 has been taken away. Okay, so these are the categories of fundamental rights. Right to equality, 14 to 18. Right to freedom, 19 to 22. Right against exploitation, 23 to 24. Right to freedom of religion, 25 to 28. Cultural and educational rights, 29. Article 29 to 30. Right to constitutional remedies. Okay, so now let us understand the difference between fundamental rights, constitutional rights, and legal rights. Okay, fundamental right, constitutional rights, and legal rights. Okay, so as you know, fundamental rights, fundamental rights are the rights that are being recognized by the Constitution in Part 3. Okay, so the fundamental rights are rights that are recognized by the Constitution under Part 3, whereas constitutional rights are not present in Part 3, or they are not included in Part 3, but they are inserted in the Constitution. Okay, they are inserted in the Constitution. Now, what are legal rights? rights. Legal rights are provided under statutory laws, either of the parliament or of state legislature. Okay, so fundamental rights are present in the part 3, or the rights which are recognized by the constitution in the part 3. Constitutional rights are not included in part 3, but they are inserted in the constitution, whereas legal rights are provided under the statutory laws, both parliament and state legislature. Now the fundamental rights are justiciable. When you say justiciable, that is, on the violation of fundamental rights, an aggrieved person can move the courts for its enforceability. Okay, so they are justiciable. That is, a person can approach either Supreme Court and High Court. Okay, but here the aggrieved person on the violation of fundamental rights can directly go to the Supreme Court under Article 32. So this remedy of approaching the Supreme Court directly is itself a fundamental right. Okay, so fundamental rights are justiciable. On the violation of the fundamental rights, an aggrieved person can go or approach to the courts for their enforceability, that is Supreme Court and High Court. On the violation of fundamental rights, an aggrieved person can directly go to the Supreme Court, approach the Supreme Court under Article 32. Okay, so this right or this remedy to approach directly the Supreme Court is itself a fundamental right, whereas constitutional rights and legal rights you have to follow due process of law. You have to follow due process of law, that is from lower courts to higher courts. That is, an aggrieved person can not directly approach the Supreme Court as in the case of fundamental rights. So this is one of the difference. Now, fundamental rights are part of the basic structure of the Constitution. Part of the basic structure. Okay, fundamental rights are part of the basic structure. Whereas constitutional rights and legal rights are not part of the basic structure. Okay, so what is basic structure? Basic structure is a principle. Basic structure is a principle established by the judiciary. That is, certain core features of the Constitution cannot be amended by the Parliament. Okay, what does it say? Basic structure is a principle established by the judiciary. So according to it, there are certain core functions. There are certain core functions of the judiciary which the Parliament cannot amend. So that is the basic structure. Okay, so fundamental rights are part of the basic structure, whereas constitutional and legal rights are not part of the basic structure. Okay, so in order to amend the fundamental rights, so since we are saying that fundamental rights are the part of basic structure, so to amend the fundamental rights, you have to amend it only by the Constitutional Amendment Act. Okay, so you also learned what is basic structure. Basic structure is a principle established by the judiciary, wherein there are certain core functions, core features features. Core features of the constitution which cannot be amended by the parliament. So you have another difference, you have writ application. On the violation of fundamental rights, an aggrieved person can approach or move the court, that is Supreme Court, directly by the way of a writ application. Okay, Supreme Court directly by the way of writ application. What about constitutional rights and legal rights? That is, they by the application or the remedy lies in the application of by ordinary suit. Okay, ordinary suit. Okay, he can approach here under Article 32. So this is the difference between constitutional, legal, fundamental, constitutional and legal rights. Okay. Now let us understand the features. Let us understand the features of fundamental rights. Okay. So characteristics of fundamental rights. Fundamental rights are to whom they are available. Okay, are they available to all the citizens, or only they are available to only citizens, or they are available to other persons as well? Okay, so they are available. Some are available to only citizens. Some are available to only citizens, while others, that is other fundamental rights, are available to all persons, that is citizens, foreigners plus legal persons. Legal persons, corporations or companies. Okay, so to whom they are available? Some of the fundamental rights are available to only citizens, while others are available to all persons, citizens, foreigners and legal persons, that is corporations and companies. For what they are available? Okay, they are available, most of them are available against the arbitrary action of the state. Okay, that is arbitrary action of the state means that is against the rights of the individuals. Okay, but few of them are available against the actions of private individuals. Okay, so fundamental rights are available for both, that is arbitrary, against the arbitrary action of the state and against the action of private individuals. Now we already understood about this. They are not absolute, but they are qualified. What does it mean? That is, the state can impose, when I say it is qualified, fundamental rights are qualified, the state can impose reasonable restrictions on the rights of the individuals, and these reasonable restrictions are subject to the decisions of the court, that is judicial review. For example, right to freedom of religion, that is reasonable restrictions are imposed on the grounds of public health and morality. So fundamental rights are not absolute, but they are qualified, that is the state can impose restrictions on the rights of the individual. They are not permanent. or sacrosanct. That is sacred. They are not permanent. What does this mean? That is, the parliament can curtail or restrict or repeal or abrogate or take away. The parliament can curtail, restrict, repeal, abrogate or take away the fundamental rights. Okay? How it can take away? By only Constitutional Amendment Act, and it is subject to the basic structure of the Constitution. Okay? So the fundamental rights are not permanent, that is, or sacrosanct. Sacrosanct means sacred. Sacred in the sense not touched. Okay, so the parliament can curtail and repeal only by Constitutional Amendment Act, amending the Constitution, Constitutional Amendment Act, but it can only amend if it is not subject to basic structure. Okay, if the fundamental right is not part of the basic structure, then it can amend. Okay. So national emergency. Before that, let us talk about some of the fundamental rights are negative in character. That is, they place limitations. They place limitations on the authority of the state. They place limitations on the authority of the state. They place limitations on the authority of the state. That is, they are negative in character. Some are positive in character. That is, they impose or they place certain privileges on the individuals. Okay, so they are both positive as well as negative. When we say negative, they are limiting the authority of the state, and positive, certain privileges are given to the individual. Certain privileges are given to the individual. So, regarding national emergency, the fundamental rights are suspended during national emergency. Okay, suspended except Article 20 and 21. 21, right to life and personal liberty, right to life and personal liberty, protection against conviction from offences, Article 20. Okay, so during national emergency, fundamental rights are suspended except Article 20 and 21. Not only this, Article 19, the fundamental rights under Article 19, that is the 6 freedoms, they can be suspended only if the national emergency is proclaimed on the grounds of war or external aggression. War or external aggression, but not armed rebellion. Okay, so war or external aggression is external emergency, armed rebellion is internal emergency. So during a national emergency, the fundamental rights are restricted or the fundamental rights are taken away or suspended But except for Article 20 and 21, Article 20 protection against conviction from offences, Article 21 right to life and personal liberty. Okay, so but Article 19 can be only suspended during external emergency, that is war or external aggression, that is national emergency proclaimed on the grounds of war and external aggression. Article 19 can be suspended, but not on the grounds of armed rebellion, that is nothing but internal emergency. Okay, so Article 33. Okay, Article 33. Before this, martial law. Okay, martial law. Martial law is nothing but military rule. When the martial law is in operation in a particular area, the fundamental rights are restricted by the Okay, so these fundamental rights, this martial law is not national emergency. Okay, it is not national emergency. It means military rule, and it can be imposed in a particular area to restore law and order under abnormal conditions. Fundamental rights are restricted by the under martial law. Now, what about certain laws or martial law? So we have learned about the features, that is some of how they are to whom they are applicable. Some are applicable to the citizens only, and others are applicable to all persons, citizens, foreigners and legal persons. They are available against the arbitrary action of the state, actions of the individuals. They are absolute. They are not absolute but qualified, that is the state can impose restrictions on the rights of the individuals. They are not permanent or sacrosanct, that is the parliament can curtail or repeal only by the Constitutional Amendment Act and subject to the basic structure. Okay, so these are the features. Now let us try to understand what is Article 12. Article 12 defines the term states for the purpose of Part 3, that is fundamental rights. Okay, it defines the term state for the purpose of Part 3. That is, time and again we are coming across the word state. That is, when you are talking about imposing reasonable restrictions on the individual by the state. So what is the state? Okay, so state includes government plus Parliament of India, government plus state legislature, local authorities like panchayats or gram sabha. Panchayats, 73rd Constitutional Amendment Act 1992 to establish local self-government. Gram sabha, Article 243. Gram sabha, Article 243 to promote democracy at the grassroots level. This is a kind of direct democracy. That is, all the villagers or all the members of the village who has right to vote, they participate in the Gram Sabha. Okay, so this is a kind of direct democracy. So local authorities and other authorities. So this other authorities include both statutory and non-statutory. So what does statutory means? Statutory means those which are made or the authorities which are established under the acts of parliament or state legislature. Non-statutory, they are not. They are established by an executive order or authority. Example, statutory, you have Election Commission, CAG, Controller Auditor General of India, UPSC. Okay, here non-statutory by executive order or authority like Niti Aayog. Okay, so article again, once again, let us revise. Or Article 12 defines the term state for the considerations of Part 3. It includes government plus Parliament of India, government and state legislature, government of the state and state legislature, local authorities like panchayats and gram sabha, and other authorities. Other authorities may include statutory and non-statutory. Statutory like made under the acts of parliament or state legislature, non-statutory by executive order or executive authority. So this definition or the word other authorities is vague and extensive. Is vague. Okay. So the courts, especially the Supreme Court, had made various interpretations. Okay. Various interpretations from time to time. Okay. Initially the interpretation was very restrictive. That is, those authorities, or it defined the term state as including those authorities which carry out the sovereign functions of the state. Okay, only those authorities which carry out the sovereign functions of the state. Okay, it's a restrictive interpretation. That is, it is restricting the definition of the state to only those authorities which deal with the sovereign functions of the state. Sovereign function is what? Those functions which are only performed by the government. And this is a inalienable. Okay, this is the inalienable function of the government. Okay, so initially it was restrictive interpretation. Now later in the Electricity Board of India versus Mohanlal, Electricity Board of India versus Mohanlal, the Supreme Court had made liberal interpretation. Okay, liberal interpretation. Now what is that liberal interpretation? Now the Supreme Court has interpreted that the authorities which not only sovereign functions but also perform non-sovereign functions. Okay, it also included those authorities which perform non-sovereign functions. So it's a liberal interpretation. And again in Sukhdev Singh versus Bhagat Ram 1975 case, it further liberalized. Okay, it further liberalized by including LIC and ONGC, etc. Okay, further liberalized the definition of the state by including LIC and ONGC, and it upheld the Mohanlal case. Okay, so the Supreme Court initially there was a restrictive interpretation, that is it confined the definition of the state to only those authorities which perform sovereign functions. Now later in Electricity Board of India versus Mohanlal case, the Supreme Court has given a liberal interpretation, that is it has also included the authorities which perform non-sovereign functions. And next, the Sukhdev Singh case versus Bhagat Ram in 1971-75, the Supreme Court has further liberalized by saying that it has also included LIC and ONGC. Next, in R.D. Shetty versus Airport Authority of India, R.D. Shetty versus Airport Authority of India, the Supreme Court has evolved a criteria for the definition of the state. Evolved a criteria for the definition of the state. Now, what is that criteria? That is, it has given a guidelines. Those authorities which are given financial aid by the state, which are controlled by the state, which perform public duties or public activities, public or government activities, which perform public or government activities. Okay, so these are the guidelines. Next, under state enterprises, versus City Industrial Development Corporation, under state enterprises versus City Industrial Development Corporation by Madhya Pradesh, Maharashtra 1990, the Supreme Court has further liberalized by including any private entity or body that acts as an instrument of state. Okay. Example, Unique Identification Development Authority of India, that is in the Aadhaar case. Okay. So the Supreme Court has further liberalized in the State Enterprises versus City Industrial Development Corporation, Maharashtra 1990 case, that is private entity, that is it has included private entity or body in the definition of the state which acts as an instrument of the state. Example, Unique Identity Development of Authority of India, that is Aadhaar case. Now, whether judiciary is involved, so Rupa Ashok Hurra versus Ashok Hurra case. Okay, Rupa Ashok Hurra case, whether judiciary is involved in the definition of the state. So Supreme Court has interpreted that regarding in the performance of judicial functions, it does not include in the definition of the state. That is, it does not act as a state, or it does not include in the definition of the state. in performance of administrative functions. Yes, it is included in the definition of the state. Now, what administrative functions the judiciary performs? Now, what administrative functions the judiciary performs? The administrative functions like conducting examinations. Okay. So, this is about Article 12, that is the definition that is related to the definition of the state. Okay. So, initially the state, that is the Article 12 deals with the definition of the state for the purposes of Article 3. So, the initial interpretation of the Supreme Court was restrictive, that is only concerned with the authorities which perform sovereign functions. Later, it has evolved. That is in the case of Electricity Board of India versus Mohanlal, it has taken a liberal interpretation, that is it also included non-sovereign functions. In the case of Sukhdev Singh versus Bhagat Ram, it has included LIC and ONGC, further liberalized. Next, under R.D. Shetty, Airport Authority versus Airport Authority of India, it has evolved a criteria for defining the state, that is it has provided the guidelines, that is those authorities which are finally aided by the state, which are controlled by the state, and public activities of the government. Okay. Next, in the State Enterprises versus City Industrial Development Corporation, Maharashtra 1990, it also included private entity or the body which acts as an instrument of the state. So, this is about Article 12, that is it defines the state. Okay. Thank you.